The words proposed to be omitted stand part of the question, and I call the member for McNamara.
Thank you very much, Acting Speaker, and I commend the member for Blair for his contribution. It was a fine contribution, and I echo many of the sentiments that he made in this place. I rise to speak on this Federal Circuit and Family Court of Australia Bill 2019, and I do so stating from the outset that we on Labor wholeheartedly oppose this bill, and that I also support the member for Isaacs on his second reading amendment to this bill. And it is a reflection on this Morrison government, the emptiness of this Morrison government, that they would put forward a reform such as this. This is a significant reform that is going to affect the lives of thousands and thousands of Australians. This is a dramatic reform, and one where stakeholders and those experts in the area of family law have not just politely requested, but pleaded with the government to just stop and reflect on what these changes that the government is putting forward will mean to ordinary Australians. And of course, this government, when implementing a reform as significant as this, does not even have the heart to get its members to come up and defend it. Barely any of them stood up to talk and to defend this reform to the Family Court of Australia. Barely any of them got up and bothered to defend this action by the Attorney-General, because on that side of the House, they either don't care enough about the lives of Australians that they are going to affect by implementing this reform, or they don't believe in their own legislation. And I don't know which one's sadder, but it is evident that this government is willing to throw out one of the most important institutions in this country, and one that tackles some of the most complex and difficult problems that face Australians. And family problems are complicated. Families are complicated. Australian families are complicated. And it is not right for politicians to be inserting ourselves in the middle of their families. It is appropriate that if in the event, as the previous member, the member for Blair, outlined, that there are channels and that there are courts in which to deal with it. And of course, we on this side of the House absolutely appreciate that the system is not perfect. It's not perfect. There are things that are going wrong in the family court. There is a huge waiting list. But the way to fix that waiting list is not to amalgamate the family court and to take away the expertise and the focus and the experience that comes with having a specific Family Court of Australia and amalgamating it with the Federal Circuit. The way to fix it is actually to resource it properly, to provide the funding, the resources, and maybe even, call me crazy, maybe even appoint a judge once or twice. But the Attorney-General seems to be absolutely stubborn in his approach to this court and has refrained and refused to support the court and to give it the resources and the infrastructure and the personnel and the appointees that it so desperately needs. And some history. Unlike those opposite, who do not even bother to speak on their own legislation, which is pretty stock standard in this place. There's not many bills that this government introduces that the government MPs bother to stand up on. But as one as important as this, you would have thought at least some of them would have stood up and acknowledged the significance and maybe even defended the reforms. But that seems to be a step too far for the members opposite. But like so many reforms and like so many great reforms in this country, they were not implemented by a lethargic and stagnant government like this. They were implemented by a Labor government keen not to waste their time in office but keen to implement the reforms required to help make Australian lives and Australian livelihoods better. And so, in 1974, when the Whitlam government implemented the Family Law Act, or introduced it, it was debated in this place. It was debated. And almost half of the members of this place, in the other place down the road, spoke on this bill. They spent 28 hours, sitting hours, debating the bill. It wasn't a reform that was ignored and you throw in one or two MPs and then you sit down. The amount of Australians that are affected by this court was reflected by the number of MPs who were willing to stand up and say why this is important. But for the life of me, I'm yet to hear one single reason as to why this government thinks this idea is a worthy one. Now, going on this idea of acknowledging the fact that there is backlog, and there is backlog that needs to be addressed. This government didn't listen to the Australian Law Reform Commission. In 2019, the Australian Law Reform Commission did a comprehensive report on the family law system. They made a number of recommendations, 60 recommendations. And one of the key recommendations and key findings was that the family law system in Australia had been deprived of resources to such an extent it cannot deliver the quality of justice expected of a country like Australia, and to whose family law system other countries once looked and tried to emulate. In other words, the Australian Law Reform Commission pointed out the most obvious problem with the family court. It is not that there isn't some amalgamation required or some watering down of the specialisation of the judges and of the appointees in the court. It was the fact that the court has been neglected, and it has been neglected by consecutive governments, Abbott government, Turnbull government, and now the Morrison government. Instead of listening to the law reform report, what this government did was commission PwC to put forward a different proposal. And PwC basically had a chick-chuck look at it over 6 weeks and came back and put forward these recommendations. But it flies in the face of experts, of former judges, the Law Reform Commission, the general public. Everyone is saying to the government, please, don't do this. This is going to hurt Australian families. This is going to hurt ordinary Australians having access to a court that they need to sort out their own internal family disputes. This is going to hurt ordinary Australians who have everyday problems in their lives and in their families. Things go wrong in families, and that's devastating, but it's also important that people have the mechanisms by which to move on. And this court and the dilution of this court is going to affect those families who are seeking that avenue to improve and get on with their lives. So we say clearly to this government, you don't need to do this. This is not a legacy that you're going to look back on and be proud that you made it harder for Australians to access the family court. It's not a legacy you're going to be proud of to look back and say, well, instead of listening to the experts, instead of listening to those who specialise and spend their days and lives dedicated to the family law system in Australia, instead of listening to those people, we just did our own thing and nobody even bothered to turn up and defend it. And we just rushed through these changes to a family court of Australia that, quite frankly, none of our members really care about to bother even coming into this place and talk about. But we're just going to do it anyway. You don't need to do it. You don't need to do it, and certainly I would say to the members in the other place that you don't need to pass it. This does not need to be passed. So The family court does tend to deal with those in vulnerable and lower socioeconomic backgrounds a lot, and it is a place where, sadly, because of the extra stresses of those families, that they do find themselves before the court at a higher rate. And to amalgamate this court, to dilute it, to merge it, is to make it more difficult and to reduce the standard of hearing for those families and especially for those kids. And the government does not need to do that. I spoke of all of those who have opposed this legislation, and one of the latest investigations, thorough investigations into this, was done in the Australian Senate, and of course the Labor senators issued a dissenting report, and one of the things that they said was that this bit of reform by the government has been almost universally condemned, and the amount of submissions by experts outlining the harm that this potential merger would do was immense. And on contrast, there was no evidence that the reforms today are actually going to fix the issues that the family court have. Instead of reducing the resources, instead of failing to appoint judges, this government has decided to introduce the legislation that is before the House today. What a good government would do is to stand in this place and say, yes, there are issues in the family court. We haven't given it the resources that it needs, but we're keen to get this right. We're keen to make sure that Australian kids and Australian families have the resources to deal with the complex family needs of Australians. A good government would get up in this place and say, here are the ways in which we're going to make this better and fairer for Australians. Here are the ways that we're going to improve it, that we're going to consult, that we're going to work with those in the industry and those who are experts in this. And what we're going to do is we're going to make sure that our duties and the duty of the Attorney-General, the highest law officer in the land, is to not be neglected, but to make sure that for every vacancy we are going to hunt down the best candidates and to make sure that the court is filled with competent and dedicated people to make this work. That's what a good government would do. That's what the reforms that are needed would look like. But instead, like the typical Abbott, Turnbull, Morrison government, they come in this place and they waste government. They waste what good government could be. And they are content on that side of the House with putting forward legislation that is not at its heart going to improve the lives of Australians, in almost like a stubbornness. In a stubbornness against the experts, they are using government to ram through bills that this country does not need. And I wonder how many people on that side of the House are entirely comfortable with the Attorney-General's approach. I wonder how many people on that side of the House are entirely comfortable with the Attorney-General and his approach of not funding the family court, of not investing in the future of the court, of not resourcing it adequately, of ignoring the experts, of ignoring the previous judges and the retired judges who have come out of retirement in order to make their point, but rather the Attorney-General's approach is to go off a short review conducted by a large accounting firm. We actually don't know because, like so many bills in this place, the government MPs haven't even bothered to turn up to this debate and to defend this reform, which is a real tragedy given the significance of it, given the harm it's going to do to Australian families, and given the impact it's going to have on Australian lives. We oppose this bill and we support the second reading amendment put forward by the member for Isaacs.
Thank you. Member for McNamara.